what we want to do, I mean, look, who'd want to pass up a chance to work with Lon? But there are going to be instances where, for whatever reason, the PERM is just not the desired way to go. And the way I kind of see it, or the way Deborah and I see it, is PERM it's a volitional act. The employer is under no obligation to launch PERM or to sponsor someone for permanent residence. There may be reasons from the employer side. Where's the clicker thing?
It's over there, Deborah, where I was standing.
There may be reasons from the employer side which says, you know what, we're just not going to do PERM. I mean, it could be, we listed out a couple of the major reasons why an employer may just not want to go down the PERM route. Prevailing wage is maybe, well, I mean, there may be disinclination just to go through the whole process. The time, the complexity, the manpower drain. Prevailing wage, the Department of Labor has some pretty strict and arguably unreasonable wage standards, and that can be a scuttling factor dissuading someone from going through PERM. There may be fully qualified U.S. workers. Whatever the reasons, there are reasons why an employer would not undertake that process. Similarly, I mean, assuming that the employer and the employee are going to be in sync, there may be reasons for the employee would prefer to explore another way. Particularly India or China, maybe they could get into a higher preference category and cut back on the time required to get permanent residence. Or there may be, PERM kind of locks someone in to a specific employer and a specific position. So if there's a desire for greater flexibility, maybe PERM's just not the way to go. Here's the thing. I think that there should be a dialogue involving employer, employee, and counsel in terms of trying to understand what makes the most sense. And in many instances, it is going to be PERM and should be PERM. I mean, that is kind of a conservative, in many ways, and this is a generalization, but a rock-solid way to go for permanent residence. What Deborah and I want to talk about is instances where, for whatever reason, PERM is not the desired route, and in many instances, or some instances, this leads us into a little bit more discretionary type of an adjudication. So it lacks some of the linearity sometimes that you see in PERM. And kind of, Deborah and I are big into concepts, which is another way, at least in my own situation, means I can't really do anything practical, but I'm into concepts. So the way to kind of, the way I see it is if, what, you're not going to what? Yeah. You can ask my wife, believe me. There are three ways. There are, three basic ways if you're not going to go to PERM, but you want to create a long-term association. You're either going to find an alternative pathway to PERM, which is what we're going to talk about. You're going to look to some of the non-immigrant options and what that can do for you. Or there's some special immigrant programs. We talked about that, TPS or special initiatives to keep someone. But literally, those are the only options. What we did in this slide is we just kind of sat and talked and came up with a listing of some of the alternatives that you'd consider if you decide not to go down with PERM. So, and some of these are going to be quite restricted to certain factual situations. I mean, marriage-based immigration, you've got to have a marriage, and you've got to have a marriage to a U.S. citizen or a permanent resident, or family-based. So it kind of requires a holistic inventory of facts. And again, that's something which I think we do pretty systematically in terms of working and just trying to understand the whole universe of factors that would create different pathways to permanent residence. And again, could be PERM, it could be something else. I want to just say a couple words about a pathway to permanent residence that I think is actually quite germane to many business situations. And that is, it's a national interest waiver. And the way it works is it's a filing that can be done by the foreign national. So this is something that could be independent of the employer. It will benefit the employer, presumably, if someone gets permanent residence. But it can be undertaken technically without employer sponsorship. And the essence of a national interest waiver is to make a connection between what the foreign national is doing and benefits to the country as a whole, benefits to society as a whole. So even though you're looking at your employees in terms of what are their contributions to the employer, to the company, by stepping back in many instances or some instances, it's possible to make a nexus really between what one of your employees is doing and overall benefits to the United States. Again, this is something which is creative, but it's not out of the ballpark. It's not out of the realm of being considered. And while perhaps the national interest waiver is used disproportionately within the scientific community, within the academic community, unquestionably, we would currently do it within a business context. And basically, there are three requirements. There are three and only three requirements for a national interest waiver. Number one, you have to identify why the activity of the foreign employee is national in scope. That is, it doesn't just benefit a limited geographic area or a very limited segment of the population. Why is it national in scope? Why is it something important? Number two is a real gimme. I mean, the legal term is intrinsically meritorious. It's got to be morally good. It has to kind of contribute to the betterment of the United States. The third element, which is where national interest waiver cases are won or lost, basically, is you have to show that the individual foreign national is so outstanding that they can make a national impact. So there's this element of showing outstanding abilities. And I only mention, or Deborah and I only mention the national interest waiver, again, because it can become a very viable option. It goes through the foreign national. They're the primary engines to it. But it's a way to kind of get away from a lot of the strictures that you encounter in the PERM process. And I think that this should be in the toolbox in many, many situations.
I'll just briefly give some examples of when we've used this. So often when I bring up national interest waiver, the first thing they say is, oh, I don't qualify. What have I done that's benefited the U.S.? And a fun case that Laura and I worked on years ago was a bald executive of a hair care product company. And I thought, if we can get a national interest waiver for a hair care executive who's bald, like we can do anything. So you can think outside the box. So I look at, national in scope. If you're creating jobs, you're benefiting the economy. Where these jobs are going to be throughout the U.S., right? If you're growing business, if you're expanding opportunities. If you work in healthcare, right? That's an impact to the entire U.S. You work in the medical community. If you work in the railroad industry, commerce can't work without ability to be able to keep our airlines clean. So there's lots of creative approaches to your business. Even if you don't have a multinational business, even if it's only in one state, you may have a national impact by virtue of what you do. Done this frequently for the energy industry, wind development, wind farms. Think of things that we think are important to us, alternative resources. How can we use that? And if you have someone who you think, well, we're really invested in this person, we don't want to lose them because they helped us achieve this next level, you can creatively use this. Often we usually think of the PERM because Bob does a lot of his clients are truly outstanding. A ton of high-level scientists, medical personnel. I often work with the almost outstanding, but not there yet in your field. Well, we have age out issues. So we just have one we're doing a PERM. Makes perfect sense. It's H1B. We're going to go to a PERM, and they go, oh, my daughter's in college, and red flags come up because the process. When do they turn 21? In December. We just started. There's no way we're going to get a PERM approved in an I-140. So one of these family members are going to lose their child. They're going to have to switch to an F1. Then you have half the family with a green card, and you have one person left out. That's no good, right? We want inclusion. We want to keep the family here. And so we brainstormed, is there a way we can do a national interest waiver? Because we could prepare that in 3 months' time. We could get that filed. And under the Child Status Protection Act, as long as we get that petition filed before the daughter turns 21, she can be grandfathered in and we can protect them. Mind you, we still have to win the case, but these are approaches that your foreign national may not know to raise to you with HR. And so it's important to think of the holistic part of the family. And because a national interest waiver can be paid by the employee, they can even pay this process. Where a company can say, all right, well, we're going to do the PERM because we have to pay for it. We know we're going to keep you here, but maybe we'll help invest half to see what we can do to help you out with your family. So sometimes you need to think outside the box to really think of the holistic approach to keeping your person.
And by the way, a company could file the national interest waiver. It is oftentimes filed by the individual because the employer opts out. But one of the values of having the employer is there's a level of respect, there's a level of gravitas to the employer, and it looks good. The optics are good, so it kind of increases. It can increase the chance of success.
I'm just going to give you a real quick 101 of family-based immigration, because something that also comes up, and I think an employer can save money, is when you find out that they're marrying a U.S. citizen, and you think, great. Well, a lot of times companies are willing to pay for that process because they've just saved themselves all this money in PERM and fees and years of H-1B extensions. Like, you don't even need the marriage to succeed. You just need it to be approvable. They get the green card. Your hands are free. It's a fast track. So if your employee's here legally and they marry, with the new Supreme Court case, marry either gender, it's fantastic. They can go forward with sponsorship for a green card. It's very fast. I would say you could probably have a green card within 6 to 8 months versus what we're hearing about with normal processing. For certain nationalities, I'll say it's going to be more rare for a lot of certain nationalities to marry Americans versus their own country they're from. It's just a lot of cultural differences. But it's an important avenue to consider. And sometimes you may find out maybe they had a preference petition filed by a sibling years ago or a parent that may become current. So it's just worth brainstorming whether those are options. We talk about timing and quotas. If we get to it, we can explain what all these backlogs mean because it truly changes everything you do by understanding how long the process can take in terms of what you're investing in non-immigrant visas, what you're investing in the green card process. Intracompany managers or executives. So as you discussed for the L1As and L1Bs, the beautiful part of an L1A is there's a part for an I-140 multinational manager petition. Regulations are almost exactly the same. So if you have someone here who is on the L1A, it's an excellent process to go down the I-140 multinational path. Why do we like it so much? It's first preference. And what that means to you, if you are someone who's subject to the backlogs, you've just gotten rid of that backlog. You're now in a very high preference category. And there's strategies we've made where we've sent individuals abroad. We've had lots of individuals who worked their way up through a company who never had degrees, for example, but they've been with the company for 20 years. And we say, well, if you want to go send them to work in your Malaysia plant for a year as a manager, bring them back over, we can then file them for a green card. If we try to do a PERM with unskilled, it's going to take forever. And then it includes their spouse cannot work, and it's a tremendous opportunity. But of course, they don't make it easy, right? The threshold of getting these is getting harder and harder. There are questioning, can you really be a manager? How many people are you managing? Are they truly professionals? If you're an executive, do you have enough people to actually do the everyday administrative duties to show you're only making high-level decisions? Because we all know that's all you do as an executive, just make decisions. But it's very important to strategize. If you have the ability to have a multinational company with expanded offices abroad, definitely take a look at this avenue.
If I can just add one thing, elaborating a little bit. the whole notion of intercompany transfer, I think, came out of when it was formulated. It was really done on a 1950s, 1960 business model with kind of rigid departments and hierarchical structure, and manager meant to manage and direct and fire and everything. And that's not how companies work. I mean, it's not just the fact that you've got leaner organizations, but you've got much different corporate relationships. Begrudgingly, immigration, I think, is moving in that direction. I mean, there's elements, a concept of functional manager, which is simply authority over a business unit, for example. And so my only point is kind of elaborating, just on what Deborah's saying, is that, yeah, there's certain rigidities, and I think that immigration has a good deal of skepticism on the intercompany transfer. But having said that, I think the environment is getting better and better, frankly. I think it's getting a little bit looser than certainly when I started practicing. Yeah, I know. Long time ago.
Okay, the EB-5s. I am really not the one to talk about that. June should be, or Laura. They are our EB-5 specialists within our group. I know enough to refer you if you are interested in the EB-5. Basically, it is, right now, you have until September 30th to use this program. I'm not kidding. It's set to sunset. And if Congress doesn't take action and extend it, it goes away. So in the next 12 days, you have, we have quite a few that need to be filed in 12 days. If you made $1 million investment, or $500,000 if it's in a area, shortage area for labor, you can create your own company that's going to generate 10 jobs in America. You can get a green card. That's the process. It sounds so easy, but it's very complicated because you have to trace your source of funds. Because of course, everyone bringing in money must have got it retained in legal means. So you have to document every source of where your money came from to confirm it came through legal means, and it's easier said than done in certain countries. You also have to make sure you are going to generate only conditional, so kind of like marriage to a U.S. citizen, and you wait to see, did it really work out after 2 years? Did you convince us it was a real marriage, but it turned out to be fraud? It's the same thing with this investment, except you have to show that you did generate the 10 jobs and that you actually used this investment. You could just be sitting in a bank account, safe and sound. You actually have to put your own money at risk into this venture. But for many of those who have means, it's an excellent means of getting a green card. Wait till we hear the news what happens after 21. Most likely they're going to be raising the threshold investment amount. This came out in 1990, so it's been a long time. So that's about it. That makes sense. Real quick on the DV lottery, basically the U.S. has 140,000 immigrant visas for employment. 55,000 numbers are available for diversity visas. So America does want to make first, what we're looking at are countries that we don't get a lot of people to come here. Okay? So it's not going to be people we get a lot of immigration from. You're not going to get Canadians. You're not going to get England to apply. But I would say about 80% of the rest of the world can apply. It's literally you go online at the start of their fiscal year, you enter your application. I think you have to have 2 years of high school education, and that's pretty much the threshold. And it's totally random. And when I meet people who get a number in the DV lottery, it is so exciting because I'm like, you really did win the lottery. Oh my gosh. You have to adjust and get your green card within that fiscal year. So, every year I get a few. One of my favorite was a law student who got this. And it was a number where we knew it was going to be current literally like the last month. So if you didn't get your green card in 3 weeks, that was it. You lose your chance. So this whole future, right? Investing. Otherwise, to get an H-1B as a lawyer, it's not so easy. And it worked out. We got it right on time, but it's like those kind of dream happiness. Well, and there's nothing wrong with trying. It doesn't cost you anything. Be careful. There's a lot of fraudulent websites that will tell you you can pay us, $2,000 and we'll file for the DV lottery. You don't have to pay money. When you Google, often the first things you see are the fraudulent ones, so be very careful. But it's a great. There's nothing wrong with your employees trying to do this. They could get lucky.
I tell you, half the cab drivers in New York City are DV lottery winners. So yes, it does work. Okay?
That's it.
Thank you.